Okay, so hasn't been very many days since the ruling on the Emergencies Act was given from the Commission, and this is Justine's reaction or Justine's thoughts um, on it. So she's from the Canadian Constitution Foundation. She doesn't think that it should be over and wrapped up at this point, and that it really needs to be sort of revisited or thought over. So haven't I haven't listened to her thoughts in its entirety. So I'm going to do that now and sort of give my own reaction and my opinion to it. So let's go.
Low report about the federal government's use of the Emergencies Act. And I'm going to tell you what I think this report got wrong a lot and why this isn't the end for the Trudeau government. I can't wait to tell you all about it. If you're new here, welcome. My name is Christine, and I'm the litigation director for the Canadian Constitution Foundation, which is a legal charity that fights for fundamental freedoms in Canada. We were also a party to the Emergencies Act inquiry. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below.
Yeah, so she does put out regular videos on things that pertain to the Constitution. The Emergencies Act being one of the biggest things happened recently. Her channel is excellent. I definitely recommend that you check out the Canadian Constitution Foundation website, their YouTube channel, and subscribe to them.
It really helps my videos out a lot. Also, please remember that nothing in my videos is legal advice. If you have your own legal question or problem, please consult your own lawyer. So on February 17th, Commissioner Rouleau released the final report of the Public Order Emergency Commission. This was the public inquiry into the Trudeau government's decision to invoke the Emergencies Act in response to the 2022 Freedom Convoy. We immediately reviewed the report and responded with a statement. The report was very disappointing. I know Commissioner Rouleau had a really hard job. The report was produced on an exceptionally tight timeline following 6 weeks of sitting through hearings, and the report is over 2,000 pages when you include the exhibits.
Now, the timeline was tight overall, but the timeline was especially tight for anybody giving evidence or anybody testifying to why it might not have been justified for Trudeau to invoke the Emergencies Act. I think they were maybe given like a couple hours of notice on some key pieces of evidence, even. It's just they were given very few opportunities to give testimony, to cross, people understand that kind of thing. So very, very tight, but tighter for even tighter for others.
Frankly, the report is exceptionally and overly deferential to the government.
That is true. Like they really it came to a point where there was just Rouleau was basically not looking at evidence just to protect the government.
Real nub of the report sees Rouleau concluding the cabinet was justified in invoking the Emergencies Act on February 14th, 2022. The commissioner found there was credible and compelling evidence supporting both a subjective and objective reasonable belief in the existence of a public order emergency. The decision to invoke the act was appropriate, according to Commissioner Rouleau.
If you've read the wording of the Emergencies Act and how it can be invoked, it's a really big stretch on how they could have possibly justified it. But Rouleau did apparently somehow. I don't know. Um, we'll see what Justine's thoughts are on that.
Low. This tone is cautious and measured, and it's an exercise, I think, in pointed diplomacy and balancing, but really wanting in clarity. First, for Rouleau to arrive at this conclusion, given the posture of federal cabinet witnesses at the hearings, It implies an extraordinary amount of deference to a carefully shielded government decision-making process. The entire basis of Cabinet's concern that the protests had evolved into an unmanageable situation remained completely opaque to the Commission.
Yeah, unmanageable how? Like, unmanageable. Yeah, I don't understand it. Like, there were a lot of things that were said about the convoy. Um, that things were just chaos and nobody could live or work there or anything. That was highly disruptive. Um, I didn't see that. I don't think any of us saw that who have been paying attention to the daily live streams from multiple sources of the Freedom Convoy. It had more of like it almost had more of a block party feel to it. There was a lot of celebrations going on, a lot of sharing of food stories and dancing. Um, there wasn't the kind of disruption that they talked about. Businesses that were shut down of their own accord or by by somebody else other than the Freedom Convoy. So, for example, like the businesses in the mall, they were shut down by the mall, not by the Freedom Convoy. And other businesses decided to close on their own. Now, every street that the Freedom Convoy occupied, at least a lane was left open. If a lane was not left open, that was because of the police barricades, not because of the Freedom Convoy. So I don't know how more, like what needed to be managed. There was no violence, there was no property destruction. And as far as I could tell, there was no disruption to the ordinary things that people needed to do. So, what needed to be managed?
Remember, there was this exchange where Attorney General Lametti claimed that Cabinet, in invoking the act, was acting on the basis of a legal opinion that he said held that threats to the security of Canada were met within the meaning of the act. And it was necessary to refer to this legal opinion because the overwhelming evidence from actors and decision makers who were receiving on the ground intelligence from Ottawa was completely to the contrary. For example, during the hearings, we heard from the director of CSIS, who had concluded that the Act's thresholds to threats to the security of Canada were not met. We also heard leadership from the Ottawa Police Services, the OPP, and the RCMP state that existing criminal law tools were sufficient. No other threat or assessment of the inadequacy of existing legal authorities was performed.
Yeah, not only was existing law sufficient, like it was, they found that the Freedom Convoy people did not meet the criteria for them to go on a mass arrest of what they're doing. Like they stayed within the bounds of peaceful protest, so that they did everything that they needed to do. And as for the rest of it, like if the federal government wanted them to do more, well, on what basis, right? Based on the laws that they had and based on what their procedures are, those things that the federal government wanted the police to do just didn't need to be done, especially when people are being very cooperative, when communication channels are being left open with the police. And sort of the influential people in the convoy are working with them to clear out spaces that needed to be cleared out and so on. So yeah. Anyway.
Independently of the country's law enforcement, there was virtually no substantive basis upon which Cabinet could have concluded that the circumstances in Ottawa met the threshold for invoking the act. This whole opaqueness led to one of the more memorable exchanges in the commission when one of the lawyers for the commission, his name is Gordon Cameron, sort of resisted the conclusion of Attorney General Lametti's evidence. He said, Commissioner Rouleau, we are in a conundrum. We have attempted to find a way to lift the veil that has created a black box around what has turned out to be a central issue in the hearing. Keep in mind that assessing the reasonableness of Cabinet's decision was the whole crux of the inquiry. Rouleau then addressed the Attorney General directly, and he said, Lametti, I'm having a little trouble. How do we assess reasonableness when we don't know what cabinet decision makers were acting on? Do we just
Yeah, so they weren't being very forthright about what information they were making their decisions on, what kinds of considerations they were weighing. Um, Also, there was a conscious attempt to shift the conversation to whether the Emergencies Act was justified to whether it was beneficial. Now, those are not the same things, right? It could have been beneficial towards ending the protests, maybe. So it could have served in the interest of the federal government. But um, is that, you know, is that for the benefit of Canadians in general? And also, the benefit is really irrelevant in the question of whether it was justified or not. Justification of the Emergencies Act is not resting on whether it was beneficial or not to the situation to some party or another. The justification conditions are fairly straightforwardly laid out. So if they can't meet them, they can't meet them. It's relevant who it benefits.
presume good faith? And Lametti, of course, was happy to affirm this. And then, judging by Rouleau's conclusion in this final report, it looks like presuming good faith indeed turned out to be sufficient for him. Remember, a requirement of invoking the Emergencies Act is that it is a measure of last resort. Specifically, the Act says the emergency cannot be effectively dealt with under any other federal law.
I don't know how you can assume good faith when Justin Trudeau has stated so many things that were prejudicial against the Freedom Convoy, calling them a bunch of racists and misogynists and all that nonsense. So, how would you presume good faith in this process?
The report emphasizes the word effectively, calling it an important modifier. And this seems to confuse this requirement that all other avenues of action be exhausted with a sort of argument of convenience. The report says there may be situations where other federal laws could technically apply to a situation but still fall short. Practical considerations must be taken into account, such as whether the resources exist to enforce existing authorities, whether they would be effective in resolving the situation in a timely way, and whether they would address the situation safely.
So the problem with the shifting over to the convenience argument is, and I think Justin is very correct to point this out as a problem. The problem is like where does that put us? Does that open up the possibility of a municipal and federal or provincial government purposely not acting on a situation so that it helps the federal government enable the Emergencies Act on a given situation where normally it wouldn't be allowed? Like even though the normal regular laws and the police forces can handle it, they purposely don't. And as a matter of fact, as a matter of convenience, that um, things cannot be handled with existing laws because they simply won't or refuse to for political reasons. Is that like how does that fit in with the high bar that we're supposed to have for the Emergencies Act?
Essentially, incompetence may be what the new threshold is, according to this report. Evidence from law enforcement was that at best, the boost provided by the Emergencies Act was helpful in resolving the protests, but it did not actually substantially alter the plan to clear the protest.
Raviolis.
Don't just eat that.
I'm
You're gonna
terrified.
be
Right.
unhealthy.
So she's pointing out the same thing that I was, basically like things being helpful but not justified.
Into place by February 13th, before the Emergencies Act was invoked. Laws that already existed in the criminal code gave law enforcement the tools it needed and that they ultimately used to clear the disruptive protests, to compel tow truck operators to remove illegally parked trucks, and to call in reinforcement police from across the country.
So the question is, how disruptive was it, and who was it helpful for? Was it helpful for Canadian democracy in general? Not really, because peaceful protest is a cornerstone of it. Was it helpful for the federal government? Just clear and embarrassing situation. Maybe, but um, that's not really what's at stake here when we're considering whether it was justified to invoke the Emergencies Act or not.
The report both acknowledges and dismisses this, saying, although there continue to be laws such as the criminal code that, if effectively used, could bring the protest under control, it was apparent that law enforcement had serious reservations. This is bizarre because not a single law enforcement witness testified that they requested the invocation of the act, nor that they needed more tools than already existed at their disposal. Now,
Yeah, all the police forces went up there and saying like they didn't need it. I think the most that they said was, yeah, it was helpful to get done what we wanted to get done, but that they could have handled it without it.
Rouleau in his report is also harshly critical of the Ottawa Police Services in general and former Chief Slowly in particular. He cites a breakdown in communication, in incident command, and a breakdown even in the system that the police had to ensure that their own intelligence reports were disseminated. All of this, I think, is probably justified criticism. But for Rouleau to use these findings about the chaos among law enforcement and the finding about insufficiency in state capacity to respond to a crisis is really just a way of bootstrapping the invocation of emergency powers, and it is a lamentable and even dangerous precedent. Incompetence and chaos is not the legal threshold. Finally, the report seems to accept the federal government's novel and even Hail Mary type of legal argument that the definition of threat to the security of Canada in the Emergencies Act is different from the definition in the CSIS Act, even though that definition is incorporated by reference into the Emergencies Act. The report finds that the two decision makers, each interpreting the same words in the context of different statutes, can reasonably come to different conclusions as to whether the threshold is met.
That's a really weird thing. This is something that I haven't looked into in detail so far. Whether the CSIS criteria of an emergency and how that ties to the Emergencies Act, like what the history of it was, and how it contributed to the wording of the Emergencies Act. Interesting.
We disagree. And in fact, I think that this argument is dangerously misguided. It clearly strains the well-documented intention of Minister Perrin Beatty and the drafters of the Emergencies Act, who were very careful in intentionally incorporating the CSIS definition into the Emergencies Act. They specified that the definition threats to the security of Canada is the same as that in the CSIS Act, right in the text of the statute. And that standard was intentional.
Well, that clarified it.
Meant to be, to use Beatty's words, very stringent indeed. But the argument goes from, I think, misguided to entirely untenable when you consider what we heard from evidence from each of the relevant inputs about who would have been aware of on-the-ground situations. And not a single one of these on-the-ground policing or intelligence officers testified that a threat to national security was met. The report gives Cabinet this huge, wide spectrum of reasonableness in invoking the Act that is completely unsupported by the statute's strict definition. Commissioner Rouleau doesn't quite find that an actual situation presenting threats to the national security of Canada has crystallized. In his conclusion, he writes that the situation Cabinet was facing was worsening and at risk of becoming dangerous and unmanageable. In other words,
So it wasn't even dangerous or unmanageable yet. It was at risk of it becoming so. That is ridiculous.
there's kind of this, whiff of danger in the air. And Rouleau makes a great deal out of the diagonal paraphernalia recovered in Coutts, Alberta.
Right. I don't know how that has anything to do with the Ottawa protests. And also, are we seriously acting in anticipation of things now? Like even when no, I mean the diagonal thing. I'm gonna have to make a separate video on that. But as far as I understand it, that was more of a meme than anything else. And then for Reload to make a big deal out of that, it seems very silly, very silly. Um, wow. Anyway, so I notice a lot of this going on. Like, there's a lot of people saying, "Well, yeah, as the Freedom Convoy, it could have done this, it could have done that, it could have been dangerous, it could have resulted in these." Well, you know what? Until something happens, how do you react to the thing that never happened, right? And it's not even like they have evidence that it will imminently happen. It's basically just picking stuff out of the air, just wild guesses that something could happen. That's not a that's not a reasonable way to go about it by any means.
inferring that it might suggest similar ideologically motivated extremist factors might materialize in Ottawa, even though no policing witnesses testified that there was any evidence of such a presence. And Rouleau acknowledges that no links like that were found. So, fearful of this whiff of danger, Rouleau
So, I mean, it's really not good to not even have any evidence and just go by possibilities of imaginings of things.
found that cabinet was reasonable in invoking these emergency powers. Now, this scope of latitude and deference is appropriate for assessing, on the ground contingent actions of police who indeed we properly give wide operating bandwidth to. But the same standard is completely inappropriate for sitting, properly briefed cabinets, sober deliberations in the face of well-established and a rightfully high legal threshold for invoking the extraordinary powers to detain peaceful protesters and freeze bank accounts without due process. And
Right. Often, police officers, especially, they'll be given some leeway to make a judgment call on the scene as the situation is happening right now, kind of. But for for a bunch of politicians to be sitting in a chamber and pretend that whatever is going on is as imminent as that is rather silly.
and to suspend insurance throughout all of Canada. But this report, as I have said, is not the last word on whether the Trudeau government's use of the Emergencies Act was legal. We have brought a federal court judicial review of the use of the Emergencies Act, and there has been a hearing scheduled for April. Now, this judicial review has been brought independently, unlike the commission, which was convened and appointed by the government.
Good. Hopefully, something will come of this. So basically, the commission was not. I mean, it wasn't the end all be all because it wasn't a judicial review. It was basically just a commission. So whatever the findings are, whatever the recommendations are from the commission, it's more like, okay, that's nice. We have that. And then maybe we'll do it, maybe we won't. Now, as far as judicial review goes, I'm waiting to hear on how that goes. Uh, it'll be a lot less. Uh, it'll be a lot harder to get away with being deferential to the government and giving them all sorts of leeway because, a judicial decision is going to need a lot more solid reasoning than that. So hopefully we see a good outcome.
And that decision will carry the binding force of law, unlike the commission report. Now, depending on the outcome of that judicial review, there may get, and we hope there will be, consequences for what we think is the government's illegal use of the Emergencies Act and the unconstitutional regulations created under the Emergencies Act.
I'm not putting much faith in it because, whoever, I don't really have much faith in Canadian judges. But their lineage traces way far back and their political ties are strong. So I don't know how this is going to be. Um, we'll see.
Emergencies Act. If you want to find out more about that judicial review as it progresses, I'm going to have updates. I'm planning on actually live streaming from Ottawa each day after the hearings, just as I did when I was in Ottawa for the Public Order Emergency Commission. So be sure to subscribe to the channel, and there's a little. You should see a little bell icon below if you look underneath the under this video, and if you click on that bell icon, you
So that's also, yeah, I don't know what I'm guessing that the judicial review is not going to be televised. It's not sort of like a public thing like this commission is. So it's probably going to be completely just private. And so that's my guess anyway. Maybe I'm wrong. But yeah, I look forward to checking out Christine's comments on it afterwards for each day of the I think you guys should all check out her channel and subscribe and check out what she has to say after each day of the judicial review.
will get a notification when I'm about to go live. So you can watch all of those videos live as they happen in April. You can also sign up for our email Freedom Updates so you receive information about this case and everything else that we are working on if you visit the ccf.ca/freedom updates. And I will also post a link below in the description to the entire Rouleau report. As I said, it's over 2,000 pages when you include the exhibits. So I would love if you can go through it as well, and if you want to point me to anything that you found particularly interesting. And of course, if you want to support our fight against the federal government's illegal and unconstitutional use of the Emergencies Act, you can donate to our legal fees, which are quite high, if you visit the ccf.ca/donate. And as a registered charity, we do issue tax receipts. Okay, that's all for this update.
All right, thank you very much for your thoughts on that, Christine. I've always found their channel extremely informative and just worth subscribing to. So subscribe to that. And I'm really anxious to find out what happens from the judicial review because whatever happened in the commission was not good. That was not a proper review of things. And hopefully we'll get a better one in the judicial review. All right.